seconds to go. Start. It is submitted therefore that such an order is as such beyond the scope of the writ petition before the High Court. Making the above submissions, it is prayed to allow the present appeal. Shri Nishant Patil, learned counsel appearing on behalf of the respondent, has supported the judgment and order passed by the Industrial Court and confirmed by the High Court. It is submitted that in the facts and circumstances of the case, when the Industrial Court found the order of dismissal disproportionate to the misconduct proved, the same can be said to be an unfair labor practice as per item number 1G of Schedule 4 of the MRTU and PULP Act 1971. Thus, the Industrial Court rightly interfered with the order of dismissal, and the same is rightly confirmed by the High Court. It is contended that in the present case, as such, it was not the fault on the part of the respondent driver, that the jeep driver coming from the opposite side was on the wrong side of the road and the respondent tried to avoid the accident. It is submitted that the criminal court found that even the jeep driver was also negligent, and considering the fact, the criminal court acquitted the respondent driver. The judgment and order passed by the Industrial Court ordering reinstatement without back wages but with continuity of service does not warrant any interference. It is submitted therefore that the High Court rightly did not interfere with the judgment and order passed by the Industrial Court ordering reinstatement without back wages. Making the above submissions, it is prayed to dismiss the present appeal. We have heard the learned counsel appearing on behalf of the respective parties at length. At the outset, it is required to be noted that in the departmental proceedings, the misconduct alleged against the respondent driver of driving the vehicle rashly and negligently, due to which the accident occurred, in which 4 persons died, has been proved. Thereafter, the disciplinary authority passed an order of dismissal, dismissing the respondent workman from service. The labor court did not interfere with the order of dismissal by giving cogent reasons, and after reappreciating the entire evidence on record, including the order of acquittal passed by the criminal court. However, the Industrial Court, though did not interfere with the findings recorded by the disciplinary authority on the misconduct proved, interfered with the order of dismissal solely on the ground that punishment of dismissal is disproportionate to the misconduct proved, and the same can be said to be unfair labor practice as per item number 1G of Schedule 4 of the MRTU and PULP Act 1971. The same is not interfered with by the High Court. Stop.